Hello, and welcome to another episode of the Business of Higher Ed podcast, where we dive into the critical issues shaping the future of post-secondary education in Canada and beyond. In today's episode, we're tackling a subject that's becoming increasingly essential for institutional leaders navigating the complex legal landscape of higher education. And to help us along on this journey, I am thrilled to welcome as a guest esteemed international lawyer, litigator, arbitrator, mediator, John Campion. John has been a trusted legal advisor for about 45 plus years in public, private corporations, family enterprise, regulation, government. He provides advice, he provides representation before the courts, tribunals, governments, arbitration, mediation. He is a strategic advisor. John's status as a emeritus bencher, and for many, many years as a bencher of the Law Society of Upper Canada, the governing body of the legal profession in Ontario, and his presidency of the Federation of Law Societies of Canada. These things are very, very relevant in terms of the topic we're going to discuss today. He's nationally, internationally recognized as Canada's senior leading trial lawyer, appeal and arbitration counsel. He is what we would call in the legal profession a bet the farm lawyer. And that is, can you provide us some context in terms of what you see as the intersection between post-secondary education and law?
Thank you, David. Yes. So I'm going to do a very quick historical review. I've been involved in universities since at least 1964, either as a student or as a teacher, and continuously, really, from that day to this, and as a litigator. There has been a radical shift from the attitude of the public, students, and administrators at the university level from 64 to date. The student body in 64 was determined to make a separation between business and influence in favor of the notion of purity of education. Now, we're talking about the art students here. There were some, obviously, professional schools, but not many law schools, interestingly enough. Osgoode was predominant up until 1948, and then they had U of T, and Halifax was out there as well. And of course, Quebec had its own law schools. But there weren't that many as there are now. The medical schools were a bit of the same. There were a few, but they weren't everywhere. And in fact, universities weren't that plentiful in the province of Ontario. And over the last 60 years that I've been involved in education, fundamental changes which predated when I started, but were just beginning. Universities went from somewhat private institutions, and similarly, so colleges, to the extent they existed at all, like Fanshawe College or what used to be called Ryerson. And today's world is fundamentally different, largely because the government became not only the funder of these institutions and the builder of these institutions, but also the regulator of these institutions. And and the money flowed with the regulation. And so there's huge regulatory framework now that education sits in that it didn't before. So now the intersection between law and education has become more complicated because you've got a huge regulatory framework imposing itself with money on the institutions. And let's just take Fanshawe College because it'll come up as a good example to us in London, Ontario. And the other universities have the same set of obligations. You've then got, besides that, you've got a public who's interested in what's happening. And they tend to fund privately various things like business schools and colleges and get named, and hospitals, which are part of the university health network, And on it goes. Those funders are another constituency. And when there was a blowout dealing with a religious set of issues, or it looked like it was anti-Semitism, people withdrew their funds. A president of Harvard had to withdraw. And so you've got huge constituencies out there who are important that university presidents have to deal with, and they may have different views than the government of the day.
Mm-hmm.
Then you've got students. They used to come and expect to have a higher education and accept the fact that, and pleased to be there, that they were accepted. And the programs were general arts with specialties at the end of the rainbow, be it medicine or be it law or be it business. Well, now there are specialty programs, in particular at the community college level, which are the reason for existence, and they're connected to jobs. So not only do you have students who are now worried about getting employed, but you're also worrying about or concerned about your students who come out. Are they going to get jobs? And at the business school, where I just graduated from the Rotman Bocconi Business School program, they're interested to know what we're earning. How much more did we earn? So they do surveys to see whether their schools meet the test of having got an MBA, you're going to get an increased income. And so the constituencies, the students, the graduates are all very aware that the schools are going to now publish this. And if they publish it, the question is, what comes of it? Now, on top of this set of complications, colleges and universities and all other institutions that are looking for students, and they're competing for them. So they tell everybody what their schools can do for them. And as soon as you start talking, people are going to say, is that true? And the truth won't be known until you finish the degree. And so you've got people who say, look, not only do I have colleges telling me that this is going to be the successful result of my attending the program, but you've also got contracts that exist or alleged to exist between students and the university, which arise out of what they say on websites, which they talk about course outcomes. You might be able to get licensed, medicine, law, whatever. Those are statements which may or may not be just misrepresentations. They may be contracts. So then you have that, and you have the outcomes. When you start making statements, you can be alleged to have misrepresented the situation because it wasn't true, or it became not true at some point in time. At that point in time, you might have an implied term of contract, or you might have a negligent misrepresentation, or just negligence generally. You've got obligations in the Fanshawe College case that's just been started dealing with paralegal education, where they have criteria that have to be met from the Law Society in their courses. And it's being alleged that Fanshawe didn't meet those criteria. So you then have the Law Society who's regulating the college to see whether they meet those criteria. And they come in, they say, you aren't. Well, that might be a short-term problem, which they can correct, or it may be a permanent problem, or it may be historical and it's affecting the people who got the degree who can't get a job.
And just to interject there, you were a leader of licensing, bringing the licensing of paralegals under the Law Society of Upper Canada, as it was then called. So you're very, very familiar with this paralegal regulatory system.
Sure. And so I was a bencher, which is an elected person from the profession. And we were considering, and I'm guessing now it's somewhere in 2006, we were deciding whether the Law Society would regulate paralegals. And it had been refused on a number of occasions, thinking that, no, the Law Society is only for lawyers. Basically, the Law Society set up the program, and the benchers decided to include paralegals under the umbrella of the Law Society of Ontario, which is a huge increase in their presentation to the public. And it gave them credibility that they didn't have before. But that then meant that we had to, the purpose of the Law Society is not to help lawyers, it's to protect the public. And so if lawyers are not doing a proper job, or they're doing something that's negligent or fraudulent, then the law society can intervene. Beside the courts can intervene, but the law society can intervene and take a person's license away or penalize them. So that's number one. Number two, paralegals are now in this system. And so we had to protect the public from paralegal action. And by that, I mean, not because they weren't good, they were great. They're doing great things, but some don't do so well and some don't act properly, in which case you're now regulating. So all of a sudden the law society has grown from regulating, I think we're pretty close to 90,000 lawyers now, and add in the paralegals. And I just don't know what those numbers are, but let's assume there's 30,000, although that's probably too high. And all of a sudden you've got a huge complement of new people to regulate in different standards. And so you got to license them, and you got licensing standards. So all of a sudden now, Fanshawe College, if we're going to use it as an example, has large regulatory obligations to the ministry as to what they have to meet, what they can charge, all those kinds of things. Whether they do it on a micro level or not, I don't know, but I assume it's at a broad level, not at a micro level, program by program. To the extent that there's a professional program, they jumped in the bandwagon and decided to open it up. It's in effect having, the equivalent of a law school for paralegals. And they have a 4-year program, but they have to meet the law society standards in order then that the people who graduate can, 1, write a licensing exam, and 2, be licensed. And so you got 2 things that could stop somebody or recognize the program doesn't work. If your people aren't getting licensed because they can't pass the exam, then you're not giving them a good enough education, possibly not. Secondly, you got to meet the criteria of the law society, which they review the program every 5 years at least. So they walk in and they say, are your professors up to standard? Are your programs up to standard? Are you teaching them the level of quantity of material that you're supposed to teach? All those features are now responsibilities of program at university. Now, let's deal with the fact that you want people to come to your program, because I think that the cost per student at the time that this lawsuit was started is $16,009 or so, around $17,000, plus other costs and expenses. And I'm not sure whether that's per year or whether it's for the entire program. I got to believe it's per year, but I don't know. But it's a lot of money. And you got to think that a lot of people, don't start with a lot of funds to help out.
Right. So
then you have to attract these students. So what do? Well, you advertise. You tell them about your program. And the more you tell them about your program, the more statements you make, you have to be accurate. In some cases, these statements could turn into being a contract, and they could be just representations and therefore a misrepresentation, or as a collective, if they're not all true, or some of the essential ones aren't, it could be overall negligence. However you define the complaint in law, those words are legal words, there's a complaint that what has been said is not accurate or ceased being accurate. And once that complaint is made, you can then say, if it's not accurate, the law will allow me to have damages. And the damages are a return of the tuition, all the costs spent, and the expenses expended. Now, that's not necessarily going to happen that way, because they got a diminished program which they can supplement, and what's the supplement cost? Another $2,000, and away they go. But there's problems there. So that's the intersection of law and education, and the reason why it's arisen, because these are state-regulated entities. They're producing state-regulated programs by other people than just the Ministry of Education, namely the Law Society, and they've got people at the end of the rainbow who are they're going to write exams. If they don't pass them, what's wrong? And secondly, when they go out and practice, if they haven't got the skill set, is someone going to say, you're not good enough to get a job? And all of those things are going to be overseen through the lens of what did you tell the students? And did you meet the standards? Simple as that. Well, in this case, they've sued the Fanshawe College itself, plus the Board of Governors, entire Board of Governors. Now, that's a big job, because if they go and get individual lawyers, you're going to be in serious trouble. They won't, I don't think, but that means you got too many lawyers out there, right? But number one. But number two, they've included in this crowd that they are criticizing or commenting upon as to what they do, the president of the university or the college itself. They include the dean and associate dean. They complain about a host of other things. The dean of students, the dean of public safety. I'm not sure quite why all that's there. The program coordinator and the faculty instructors are not named as defendants, but they're named as people who are involved in the program and who didn't meet the standards. So all of a sudden, the entire from the top of the board of governors, who are presumably not getting paid to do what they do, in a highly prestigious community position and highly responsible community position, along with the president, along with a whole series of deans, program coordinators, and instructing people in the program, are under the gun and under the microscope as to what they did, what they said, and what they didn't do. And so that's now an intersection between the entire institution and this program in the institution. And in this case, the plaintiffs are all the students who went through the program who qualify up to the date the claim began and back 2 years because they've got a limitation period. So the intersection of law has arisen because of all this regulatory framework that they've sought, got, and what they said about the program, and then presented it. That's the starting point of the intersection.
Every school, every brochure, right? They're going to say, come here. We do this. We offer this. We offer you this. So that's something we're not just focusing on one case here. The value and tying the value to money or tying the value to outcomes, certain circumstances where you have multiple regulated programs. So we're talking about one right now, but let's say there's an early childhood education one. That's also a regulated program. There are others. How does leadership, because in this case, as you made the point, leadership and the board of trustees are in the crosshairs here. I mean, you've advised these types of institutions and these types of people who are on boards of trustees, right? What do they need to be thinking about and doing?
First of all, the notion of what you say as an institution about the school and about the program is a prime area of focus and care. So you have to be then absolutely sure that what you do say out there is abided by. And whatever this lawsuit has set out all the complaints that they have and the breaches of the various program terms, they may or may not be true. Court's going to decide that. And so let me deal with in that area, starting with their website and dealing with this program. And this is what has to be read carefully. Number one, it has to be what you say starting it. Number two, what you do say has to be true at the time it's made. And to the extent that it's an ongoing program, which they all are, you have to have a control system which says, is this program being reviewed? First of all, is it run by somebody who is very strong to look at the regulations and say, and look at the website and say, we are meeting these criteria. And look, at courts aren't going to go through with a microscope and say you missed this single item. That's not the problem. The problem is going to be is if the whole system has broken down and all these things turn out to be untrue or badly managed. And while there's a complaint that they are, that doesn't mean they are.
No, right.
And so what the university has to show, not that each item is right, but whether they've had a review program that's reasonable. And that review of programs, I'm sure, is responsibly done by the president, appointing head of programs who report to a faculty head, whether it's in a faculty of professional programs or whether it's in a faculty of arts or what it is, but they're going to have some head of school or who's reporting to the president. So there's a system And all of them are going to have to, as I'm sure they do, report up. So what this does is this is a lesson on how to write and what you can write fairly, and how you regulate with, or how do you oversee inside the university. And this is nothing new. Fanshawe College is going to have an entire risk analysis section. It's in the president's mind, it's in the dean's mind of the various faculties, and it's in the program review. Then each one has to do their job to ensure. And let me just give you an idea of what is in this complaint, which I'm sure if I were making a list for risk analytical concerns that the president has to ask, and then he goes to the board and he says, look, here's what we've done. Here's for every single dean, the questions they must ask, every program must ask, here's what they've answered, here's what we've got. And I can assure you that we have a system in place. Now, the system in place doesn't guarantee perfection. It's just a system in place. It's a risk diminution. It's a reporting. If they have that, they may have a complete answer or they may not. And I think in a court, when you look at all the complaints that are here, if all these complaints were true, one would say that the program was not being managed well. And the question then is that unreasonable or reasonable in the complex circumstances that occur within a program of this type and in the area in which they're doing it? And I come to look at London, Ontario. Do they have enough people to teach this many students about law? And it depends on the size of the community, because you're going to need adjunct professors like all these professional schools do. And because you can't hire enough people to fill all these jobs. So you have people doing specialties in small claims court and provincial offenses, summary convictions, administrative tribunals, and all the bigger pieces that lead into that. But how to understand what a legal professional, as a paralegal is, has to think. So the website talks about, and this is a complaint, specialized knowledge, skills required for licensed paralegals, for licensing in Ontario for the Law Society. You can become a practicing paralegal. You can upgrade your skills, and it'll give you a broad knowledge and expertise for this authorized area of practice. Well, those are a number of factors. And the question is, are they met by the program as a whole? The likelihood is they are at some level. They don't say we're going to guarantee you to be successful in the license exam. How could you? Because, there's various and sundry people. So we can only teach what we can teach. So they say that the website gives rise to a contract. Maybe, maybe not. The court will have to decide that. But it's certainly, they're representing what the program is, but it's pretty broad in general. It's pretty hard to disprove until you get into the microcosm. Then they say they look at the course outlines for all compulsory courses. And the question is, are they properly done or not? The likelihood is they are. The question is, are they affected properly? Then they say they talk in the paralegal program manual about course outcomes. And they say that to get the course outcomes, you have a program team, you have course sequencing, and you have program review accredited by the Law Society. Course sequencing, which means that they will be done in a certain order that allows potential knowledge to go forward. And then you have a program team, which is highly qualified. And it turns out they have complaints about some of the people who were teaching it full-time or part-time in the program as being unqualified. And some of it's a little harsh, I will say. Whether true or not, I have no idea. And, one person might, had been accused of plagiarism, apparently. I'm not saying it happened, but that's the allegation. Well, does that matter? I mean, if maybe it happens if you're an undergraduate or a graduate or something like that, that's a judgment in and of itself. So, you're going to disqualify them to teach for the rest of their days? I don't think so. So does that mean that the program's dead because of that? No, I wouldn't have thought so, but that's only an individual item. Add it all together if there are problems. Course sequencing is everything. You didn't do certain courses you were supposed to do. Compulsory programs weren't done. Field work wasn't done. All those kinds of things. Then the program becomes diminished in terms of its value. And therefore, did you get your full money's worth? And some court's going to have to decide each one of those issues very complicated, very judgmental, and I would say that they'll be pretty reluctant to enter that fray. Then the Law Society came along after a 5-year review and reviewed it and made some negative comments. Well, that's what law societies and regulators do. What else are you going to expect? They're going to say it's all perfect, maybe, but it's unlikely. They're going to say you need some help here, you got to have this here, da 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 da. But they're not saying your program's shut down. They're not saying you're not meeting your obligations. They're saying you need to improve. Does that give rise to a misrepresentation or not? Maybe, maybe not. So what's the answer to it all? Well, I've given to you. The president says, I've got these people reporting to me. They have these obligations, and this has got to be written down. This Fanshawe is a long-running, very complex
big school, yeah.
And then they're going to have everybody responsible down to looking at to what was taught in any particular year, one way or another. And these lawsuits are being brought by 2 so-called representative plaintiffs in a class action context. I'll deal with that in a second if you want. But they then say, well, look, there are other things that are said that become implied terms besides all these other legal things. I want to talk about, is it a breach of contract? Is it a contract at all? Is it a negligent misrepresentation? Is it negligence? Then say, all right, the contract has some implied terms that are drawn from other words. And they say, these words say they've got to be equivalent to all the other programs in the province. Well, maybe, maybe not. That's a big reach, but maybe. And time to become licensed, and that no risk in the program. They say you can't have any risk in the program. You're going to get licensed. Well, that's a big reach. That's hard to say. I mean, even if I finish law school, it doesn't mean I'm going to get called by the bar to become a lawyer. Then they say the materials weren't in compliance. They failed to adhere to the Law Society requirements, which they named. They say there are 309 requirements, and they list them all. There was no field trip. There's no lab assignments. There's no mock courtroom. The time were spent on things that weren't required, and certain requirements weren't met. The changes weren't approved when they were made. And so, okay, can there be, as a teacher, or me as a speaker right now, I'm trying to give you as many sort of hints and points that I can without trying to comment on the lawsuit or anything else. I'm saying, look, as a regulator, what can I rely upon? Well, as the president and the board can rely on the president and his staff. The deans can rely upon the program directors, and the program directors can rely upon the integrity of the reports that they get from their professors. And so it may be the whole program failed, as this would say, in part or in whole, or it may be that this is just part and parcel of a messy world. And when you have a huge institution teaching and trying to do its best to teach all these students, to prepare them for something, I don't know that you can look at the microcosm. You can look at the microcosm for each item and add them all up, but you can't look at everything and say, well, there's a failure here, therefore they're right. I think you're going to have, people are going to say, and I take it down to industrial worlds. Look at, no industrial plant's pure. They've got all kinds of mistakes. That's what they got managers for. There's a mistake, you change it. If someone gets hurt, you make sure it doesn't happen again. And on it goes. Well, if you've got a program of many programs doing a hugely valuable service to the community under the direction of the Ministry of Education and the legislature of the province, under the direction of the Law Society and with all of their bells and whistles that they're going to insist upon, and having been a regulator of this program, and having set the program up as the president of the Federation, we regulated all the law schools. So all of a sudden, am I going to expect somebody in some law school to sue the University of Toronto and its board of governors because the law school wasn't doing its job in some fashion or another because somebody couldn't get a job? Well, I don't think so. So my answer is maybe, maybe not. But everything depends on what they can prove here, and they've listed it, and I have no comment on what they can prove.
Right.
So whether they fail to meet all these complicated criteria, and whether a judge says that's sufficient to make it a misrepresentation on what they did say. But let me tell you just a couple of things for universities to look at. Not only do they what they say on their website, not only what they say in their student programs, not only what they say by the president, who gave a guarantee that they abide by all applicable provincial laws and they do what's in the best interest of the students. Very broad statements. They call that a guarantee. Well, is that a guarantee? Is it not? Is it a commentary? Is it an explanation? Is it a statement of intention? Maybe, but you got to read them, make sure that makes some sense. And if it's not a guarantee and you think you're going to fall into that category, maybe say this isn't a guarantee, but it's a statement of intent. And maybe they did anyway, but they've characterized it legally as a guarantee. Then you've got a further contract of rights and responsibilities for students. And this was negotiated between the college and the student union, and the best interest of the students, and publish relevant materials, and give notice of changes affecting students' things. Well, they're fairly standard form stuff. And, none of us is expecting a council of perfection in an institution of this side, but we are expecting a serious attempt to meet it. Does that give rise to a cause of action? Maybe, maybe not. You got this YouTube piece. They got a YouTube thing out there, and it talks about graduates who are working. 76% get jobs in 76% get jobs in 6 months.
Right.
You put yourself a number out there you have to meet. Now, is that who's speaking on YouTube? I don't know.
Which is a pretty standard thing that many schools do too, is to your point. Like that's
if
not uncommon.
Then I say to everybody, that's part of your risk analysis.
Yeah.
You can't just say it and go to sleep.
Right.
And I'm not saying they do.
Yeah.
I'm saying that and if they believed it at the time they said it and it's changed, query, do they have to measure the change and when? Big deal. So then you come to, they say, but only 4% of the candidates in 2023 got licensed. Well, what did that have to do? Was that COVID or something else? There was a law society. I don't know. Who knows? There's going to be, don't forget, the law society is going to have to come and give testimony on this thing. The president of the university and all of his deans and all the program directors, maybe they'll come, maybe they won't, because I think there'll be some common sense in all of this. And the question is, does it get settled? If it gets certified, now let me just talk for a second about this.
Yeah. Okay.
There's a process piece here. So a class proceeding is on behalf of two, in this case, representative plaintiffs who are former students or students. And they're claiming to want to have a class for all the students enrolled in the program. Now, that class doesn't just exist because they say it is there. They have to get certified by a court. You can't go without court consent. And when you do go, the court governs every single step of the way. So this isn't just a public action you can start and run on. You got to get consent. And in order to do that, you got to show you've got a proper class of people. You've got to show you've got a cause of action. There'll be a great fight here as to whether any of these terms are contracts, or whether they're misrepresentations, or whether they're exigible in law or result in any damages. So is there a cause of action? And it depends on the cause of action. Breach of contract, you don't need damages. Negligence, you do. Negligent misrape, you got to have misrepresentation. You've got to have damages. Well, they're going to say you haven't got any damages. You've then got to meet whether this is a preferable procedure and whether the issues that arise are common. Well, let's deal with negligent misrepresentation. It requires individual reliance. That's not a common issue. Negligent misrepresentation may be blown out of this case because you got to have commonality in this piece to have a class action. And before you put a university on trial, before you put an entire program on trial, and the law society's oversight on trial, and the university's oversight on trial, you have to be pretty sure that you got a cause of action here. And so there's going to be a natural analytical framework where you're really going to have to prove it up front. Now, not completely. You don't have to prove your whole case. You just have to get certified. It's a very low standard, but there's going to be huge fights. And having acted in many class actions, I have won many, many class actions at the certification stage where they were not certified. And the only plaintiff side one that I've ever taken, I didn't get certified, as it turns out. So, that's what happens. If the court doesn't like the style of it, STIG or whatever the heck it might be, or it's not preferable, there's a whole host of things going on. You don't meet a cause of action, you could lose on any of those points. So just because Fanshawe is now sued doesn't mean that there isn't going to be right up front a huge negotiation. Possibly. Fanshawe is going to have some very good lawyers. And they're all going to be looking at these pieces. And there's some superb class action lawyers in London, Ontario, or they might come to Toronto to go to a different place for whatever reasons because of local connections. A lot of the law firms might be teaching at Fanshawe. So,
Okay.
there
Yeah.
could be a conflict here, there, and everywhere in a smaller place like London. And I say that with great love and affection, may I quickly add. It's just a smaller place than a place like Toronto, where you can find lots of people who are not going to be teaching at Fanshawe, and lots of firms are not teaching at Fanshawe. So I look at all of this then, and I say, this is placing the education system on trial. It's placing the program on trial. And the question is, does it meet all these stated things that they said the program would do or not? And does the request that they didn't, does that proposition that they didn't, is that realistic? So for instance, did I guarantee that someone would pass the exam at the end of the rainbow put up by the Law Society? Well, no, it doesn't. Now,
Yeah.
maybe it does. Maybe they say that you're going to get it. Just because 76% of the people got jobs up to that point in time doesn't mean that 76% are going to get them this year. The market changes. So at some point, you have to say, there's a lot of factors are going to come in here. And if I'm defending this case or I'm prosecuting this case, all I can look at and see is, by the way, the pleading is brilliantly drafted. There's no doubt about this pleading in the Fanshawe case. Gillespie, who drafted it, I assume he drafted it. He covers the entire waterfront as to what statements were made and how they were made and who might be responsible in a very organized statutory way. He also pleads the breach of the Consumer Protection Act, saying that the representations were unconscionable. Well, that's just derivative of the representations. If they're true, well, then there's no case there. If they aren't true, fine. And the Consumer Protection Act provides for certain results, and it's a good proposition. The damages, as I've said, are tuition and costs, loss of employment income, personal damages and spent, and alleged not becoming paralegals. Well, nothing's that bad that you're going to lose everything. That you got nothing out of this program whatsoever. I wouldn't have thought. So damage itself is going to be a discussion, huge discussion. Do you get $1,000 per person because he didn't teach, didn't have a laboratory, didn't have a mock courtroom, or not? I don't know what they did in lieu of that. They said they didn't have one. Well, maybe they did it in the courtroom. Maybe they went and saw others. I mean, look at you. There's only so much money one can put up to a program like this, and actually dedicating a moot courtroom inside the university, tricky. So, I mean, maybe it's absolutely essential. Maybe it's not. I can certainly see in London, Ontario, it doesn't take very long to go from Fanshawe to the courthouse to watch what's going on every day. So you can watch it, and in the evening, get the courtroom, or go to the law school and get a courtroom.
The Western has it. Yeah.
Can we do it? And maybe they can, maybe they can't. Maybe they tried, maybe they didn't. I have no idea, and it may change from year to year. So let me just give a quick where I think I am. Number one, the regulatory framework governing colleges and universities is both an asset and a detriment. The asset is that somebody's doing the work. And you can't have failure, I wouldn't have thought, at the ministry level, the law society level, the university level, the course level, and at the instructor level going on for very long, because it's overseen. That's number one. Number two, if it wasn't, because incompetent instructors, people weren't doing what they said they were going to do, etc., it may be a diminished course, in which case there's going to be a diminished payment. But it won't be the whole shot. Number three, Fanshawe is going to have an answer. We have a regulatory framework which tries to minimize these risks. We're not foolish. We know that whatever we say, we have to live up to. And we do, they will say, as sure as I'm sitting here. So the new university is regulated. It's internally regulated. It's externally regulated. And that is a guarantee or a higher level of result. And you can rely upon those. And if there's a failure in 1 year, it doesn't mean that there's a failure in every year. And the failure may be just local. Somebody may just had a problem, and so be it. That's going to be excused at some point, because counsel of perfection, if we all lived on that level, we'd all find ourselves failing. And number three, the idea of whether there's a contract or not with the students, whether there's implied terms, whether there's statements that can be negligent or negligent misrepresentation or course production, which is negligent, that's one huge case. That means you're going to be dragging all these people from the Law Society, all these people for what they said, and they didn't shut the place down. That's the ultimate test. If they shut it down, you'd have an easier case. They didn't. They said, look, you got to better this and better that. Well, that's what regulators are for. If you go to the Human Rights Commission, I can pretty well guarantee you're going to have a negative result if you're the guy, a person against whom they're complaining, because that's what they do. They're looking for human rights and they're looking for things that are wrong. They're looking for things that are right. And you may get excused, but in large measure, you don't. And that's just what regulators do. Talk to your tax people. So then you say, right, why is this important? What's the overall societal thing? Everybody has a right to make the complaint. And the very existence of this complaint will be used by the people who are running this program to make it better.
Mm-hmm.
It will be an asset to the university. Whether it ends up in a full-scale trial, I absolutely do. They will find a way to say, look, here's what we did. Here's what we have. We recognize there's a few issues, but it didn't affect anybody. Or it did have a diminution in program because we missed 4 components of it, and we'll supply them or we'll pay each student $1,000. And let's assume that there are 500 students, so that's a lot of money. And there we go. Now, it's reputationally very damaging for Fanshawe. During the interim, it's a shock. The board of directors is going to be shocked. But I can tell you the president's gone to talk to them and tell them what the issues really are, whatever they might be. The program directors and the deans are going to be hustling to figure out what happened here, and they're going to figure it out. So it's a great enforcer. It's a potential for people who've been harmed, and it helps an institution show its strength, including the ministry, the law society, and the university. And that's what's going to happen. All of it's going to happen. Sure as I'm sitting here.
John, I finish each podcast with one thing, and that's a question.
Before you finish, I'm going to talk about your international students.
Oh, okay. Great. Wonderful.
They form part of this case.
Yes, they do.
And one of the things is that somehow they're saying that some of the representations were that you could get a work permit, which of course has got nothing to do with the university.
Right.
It's got to do with the federal government. I suspect that in the explanation, the so-called recruiters, wherever they may be, they're out there saying, look, there's always a chance you'll get a work permit once you're done your program. And you'll be, you might be better served in the application. They might say, but it's an application. But of course, people they hear the word work permit, and they miss the fact that there's a caveat to that piece. And to be frank, I don't think that anybody's guaranteeing a work permit out there, unless they were very foolish. And if they were, then they're going to pay for something on some international students. If I were guaranteed a work permit and I get here and I don't get one, I'm thrown out. Well, I might be thrown out because I had a record that didn't allow me to come to Canada. Right. And so it seems a bit of a stretch that someone's out there saying it and somebody's believing it. But these are students and they're living in places around the world. A work permit from Canada would create a lot of excitement, I would have thought, for any young person who says, if I can get into this program, I can get a work permit. And my proposition is it's unlikely to have been said. You'd be asking for serious trouble if you did, unless you gave a caveat. And the evidence will say, one, was the work permit raised? I'm sure it would, because it's a great calling card. But it would be on the basis, I would have thought, that look at your eligibility for a work permit may be advanced. That's my guess.
So this final question here. If you are the counsel, which you may in fact be, but if you are counsel to a post-secondary institution, what is the 1 or 2 key pieces of strategic advice that you are telling them you need to follow this, you need to look at this right now?
What you say can be consequential in whether you have done a proper job and therefore might or might not be liable to a claim that you didn't.
Okay.
And there are, so the program itself and its outcomes must be analyzed by people who are knowledgeable. I don't mean lawyers necessarily, but by a risk person. And every university these days or college has an in-house legal team and they will have external legal advisors. So what you do is that you, as the president, and I'm sure they do, they say, right, what are we saying about our various programs? And have they gone through an analytical framework to ensure that they are accurate? And I can't believe that isn't said generally, and I can't believe it isn't done specifically. But if it's not, have a person designated to do just that, either in the legal department or as part of the academic qualifications. And so it's what I call a risk. And because there's so much external responsibility and so many words being spoken to attract people, and so much is just said inside the institution about what we can give you and what we can't, that you just have to give a sensible, reasonable view of whether this is accurate or not. You don't have to go down to the microcosm, because who can do that? We're not looking to stop these institutions cold from going to get students, from educating students and doing all this. This is God's work. And so my view is very simple. You just have to do your best, have a reasonable program, and nobody can expect any more. And I can't conceive they don't have some of it, if not all of it. And if there's some problems here, fine. The problems are magnified here because there is a special outcome with an external exam with a license at the end of the rainbow. Yeah. And some people aren't getting it. And there are direct relationships with jobs, specific jobs, and some people may not be getting it in changing conditions. So I think that, there's going to be, this is a very comprehensive analytical framework for any president of a university and its legal department, risk analytical people, to look at and think, are we meeting these standards? And most of them will be saying we have a reasonable program to meet the standards.
All right. Thank you very much, John. So we're going to call it there, I think. I'm sure you have clients backed up waiting to talk to you. You will see, as I said, John's bio in the comment section below. If you enjoy the content that we're producing on this podcast, please subscribe, please like. If you have ideas that you'd like to hear, please include them in the comment section below. So thank you very much, John. I really appreciate your generosity of time and expertise. And to everybody else, have a lovely day. Thank you.
Thank you, David.